Good morning, everyone, and thank you for joining us for today's winter webinar, looking at the Procurement Act and the provider selection regime. For those that don't know me, I'm Andrew Daly. I'm a partner at Hempsons, and I head up our specialist procurement law team. And I'm joined by Helen Redfern, who's an associate in the team, who will say hi when we get to her bit. We've got a 90-minute session today, and we're going to be having a look at the Procurement Act and the provider selection regime. It's worth saying at the outset that we have a varied audience on the call today. So we have suppliers, contracting authorities, framework providers, charities, VCSEs, councils. So hopefully there will be something for everybody. It's also, I think, worth noting at this point that for everyone involved in the NHS at the minute, it is a particularly difficult time. I know I did a webinar the other week where I was speaking at 2, and that morning the whole of the audience had received their email about potential voluntary redundancy. So we fully appreciate that this is a difficult time for everyone involved in those discussions and thinking what the future holds. And we're looking at what procurement holds for you going forward. Procurement in all of this, with everything else that's going on, has not been made easier. The centre might want you to think that, or the government might want you to think that procurement is easier under the Procurement Act. I don't think it is. The provider selection regime requires a lot more admin than perhaps was done previously, and we'll come on to some of the issues that that is causing when we get to it. So I just want to be clear that we fully accept this is a difficult time, and procurement has not made the position any easier if you're involved in it. So let's just start off with something that I would hope everybody on this call is aware of, and that is the Procurement Act went live on the 24th of February this year. Why have I put that slide on? Simply because it is an absolute delight to be able to finally say the Act is in force and not be talking about when it might come in and what it will mean for you and what changes it will bring to you. We now can look at what changes it is bringing to you and what it means for you in practice. But a number of you may have seen this slide before. There are definitely two schools of thought when it comes to procurement at the minute and the Procurement Act. There is the those that are like the girl on the right with flowers in their hair, delighted that the Procurement Act is in and that they can use it and use the flexibility that it is supposed to have. And there are definitely the others who have their head in their hands in despair because it's not what they're used to using. It's not as easy to follow, perhaps, as previously the procurement law might have been. And then, of course, there is everybody in the middle. And what hopefully we will come through by the end of the session today is have a look at some of the things that are causing issues and things that need to be considered by those using it. So what are we going to cover today? Well, first of all, we're going to talk about the Procurement Act. We're going to look at the current position with it, the published documents. We're going to talk about the updated thresholds that will come in less than a month. We're going to talk about which regime applies. That is something that is causing significant issues up and down the country on near enough a day-to-day basis for us. We then want to look at some practical issues, how the NHS might work together, the ability to make direct awards, and then the thorny issue of contract management. We then have been asked a specific question around subcontracting prior to the event, which we're going to cover off. Then we'll look at the provider selection regime. the issues that need to be considered now we're nearly 2 years into that regime, and look at some of the advice and decisions that's coming out of the Independent Patient Choice and Procurement Panel. And we'll talk through that and see where that takes us. And then finish off with some key issues in practice and actually taking account of the Act and the PSR, what is important for you to be considering. And as I say, some time for Q&A at the end. So we have the Procurement Act 2023. We have the Procurement Regulations 2024. Those are the legislation that applies for processes going forward, and Helen will touch on what applies when. But I think it's a general observation about using Google and using AI to try and find the legislation, that often the legislation that is available on those platforms is not necessarily updated to deal with changes that happen as the legislation is amended. And there have been, when the Act and the regulations came in, some consequential amendment regulations which slightly tweaked the original version. So please make sure you are looking at the most up-to-date version of the legislation. And that really goes for the guidance notes as well. So I think everyone will be aware that there is more guidance on the Procurement Act than there has been on anything else procurement-wise over the years. And we have at least 47 sets of guidance covering what's exempt, direct awards, framework agreements, debarment, etc., etc. And that's all available by just typing in Procurement Act guidance into any search engine, and you'll get to the page which sets those out in the different categories of plan, define, procure, and manage. But these guidance notes are being updated on a regular basis. I get an email every, as it happens, Saturday morning. I'm not quite sure why I set it up to come on Saturday morning, but it comes from Cabinet Office. And it sets out updates from Cabinet Office for the previous week, and that will set out where some of those guidance notes have been updated. If you're not getting that update, unless you go into the actual guidance and look at the last updated date, it's not clear what is changing and when. But the guidance is there to help, and obviously there is more guidance than there has been before, but that is something that can be used to increase understanding of what the requirements of the Act are. There then is the additional guidance that is available. The Procurement Review Unit, for example, the CMA guidance on excluding a debarment on competition grounds. And then there is the National Procurement Policy Statement. This is a statement that contracting authorities must have regard to when they're running procurement under the Procurement Act, which it is a slightly contradictory document, but you must have regard to it when you are designing your processes under the Act. And then it's worth just highlighting what NHS England has provided for for NHS organisations. NHS England is seeking to be as helpful as possible in terms of updating standard documents for the system to use so that everyone isn't reinventing the wheel. NHS England has updated its standard terms and conditions for goods and non-clinical services and produced a number of template procurement documents, ITTs, for open and competitive flexible procedures, for example. And these are all available on the CCF Best Practice Hub pages on the Futures part of the that you have access to if you have an NHS email address. Now, the bit in brackets at the bottom is the slight plug here. Hempsons advised NHS England on these documents, So we, of course, are familiar with them, and we can assist if you need advice on looking at tender documents. But they have been designed, hopefully, so that they are able to be used without too much legal input. It's worth highlighting this because we haven't been able to publish a press release on that. NHS England wouldn't allow us to do that, but they would allow us to tell anyone that would listen. So we are putting this out there, but it is clear that there is a lack of knowledge of these documents out in the system, because we're getting documents to review where people have tried to draft their own version. Now, of course, that's absolutely fine, but when the base documents have been drafted for you, why wouldn't you use those base documents? We got a query asking us this morning to look at some marking methodology. There's standard mark, or there's template marking methodology in those documents. So it's there to try and assist. Because, as I said at the beginning, everyone is under pressure. There is the uncertainty around what is going to happen to different people's roles, etc. This is there to assist. So why wouldn't you use it to help you navigate what the new requirements are? And it's worth noting that from the 1st of January, which, as Heather said, given I'm not feeling that festive at the minute, isn't that far away, given we're not very far from Christmas, 2 weeks, start to panic, that the new procurement thresholds will come in from the 1st of January. So these are thresholds that will apply for the Procurement Act. They are going down, not by much, but they will be going down. So for processes that commence after the 1st of January 2026, the thresholds for central government authorities will go down from circa 139,500 to a smidgen over 135,000. Subcentral contracting authorities, they will go down circa £7,000. Works and concessions going down circa £200,000. But for reasons that I'm not quite sure, the light touch regime threshold is staying the same. What does this mean in practice for you? Well, potentially more contracts clearly are going to be caught. If you have a contract currently at £137,000, it will not be caught by the Procurement Act. It would be if you were commencing that process on the 1st of January. Remember, when you are looking at your thresholds, that they need to include VAT in the calculation. So bear that in mind when you're calculating it. But of course, the Procurement Act sets out a number of provisions for below threshold procurements as well. We've done a couple of articles that are available on our website as to what that means for contracting authorities. But of course, below threshold contracts will now be there'll be a smaller gap between the 12 or 30,000, including VAT, depending on what kind of organisation you are, and the threshold. And there is also a need to remember convertible contracts, because those are the contracts where if you are varying a contract that is currently below threshold and it will post variation be above threshold, there is a requirement under the Procurement Act for you to consider whether or not the variation to take it from below to above threshold would fit within one of the modifications permitted in the Procurement Act. So the thresholds are important and need to be checked. Check you're calculating it correctly. It's obviously over the lifetime of the contract. It includes VAT, and see where you fit and whether or not the Procurement Act applies for the above threshold or below threshold requirements. But there is a simple position for the provider selection regime. The changing thresholds makes no difference at all, because there is no threshold for the application of the provider selection regime. So as we're going to come on to talk to on the next slide, you need to know which regime you're in. Because if you get this wrong, as Helen will highlight, that's going to cause you a problem. But if you have a relevant healthcare service being procured by a relevant authority, the value is irrelevant, the provider selection regime will apply. So I'll hand over to Helen to look at the issues that people are facing in terms of which regime applies.
Thanks, Andrew, and morning, everybody. So first, let me say that I know that some of you are going to be looking at this slide and you'll be thinking, this is quite an obvious point, and I already know all about this. But as Andrew said earlier, people are still encountering issues with this, and it can be problematic where you get it wrong. So we are going to cover this off today. So a key starting point when you're designing your procurement is to establish which regime applies, whether that's going to be the Procurement Act, previous legislation such as the PCR or the PSR. And it's critical because it forms the basis of what you're doing in your process. And there are similar requirements in some areas, particularly when you're looking at it at a high level, but the procedural requirements are different depending which set of rules are applying to you. So, for example, we recently had a question from a client about dealing with a specific issue in a live and ongoing procurement under the Act. And when we came to look at it for them, it turned out that wasn't the advice that they needed, because actually their procurement was in the scope of the PSR. So instead of giving them the answer to the question, we were talking to them about whether they needed to abandon their process and start again in order to comply with the PSR. Next slide, please, Andrew. So in terms of looking at which regime applies, as a starting point, the Procurement Act, generally speaking, will apply to procurements commenced after its implementation on the 24th of February 2025. There are some exclusions to this. So there are transitional arrangements that mean that procurements commenced under the previous legislation must continue to be procured and managed under that legislation. So, for example, if you have an existing framework that was awarded under the PCR, then that framework continues to be managed and call-offs continue to be made in compliance with the PCR. And if an existing contract was awarded under the PCR, then if you're thinking about modifying that contract, you'll be looking at the PCR to see whether that modification is permitted. The other exception is where the PSR applies, because the PSR is a standalone regime, and where the procurement is in scope of the PSR, the Act specifically does not apply. So we've had a question in advance of the sessions, which we've been asked to deal with, and the question is about whether a procurement subject to the Act or the PSR, and the person asking the question noted that there is some confusion about where the services fall in the scope of the PSR or the Act. And certainly we would agree with that, and that is something that we see a lot and we get asked about a lot. So the question of whether the PSR applies to a particular service is highly fact specific, and in order to answer it, you need to work through the specification and apply the specific conditions. A good starting point when you're looking at that question is to take a look at the NHS England statutory guidance on the PSR, which tells us that there are 3 tests to be met to determine whether a service is in scope of the PSR. The first is whether the service is provided as part of the health service, whether the NHS or public health. The second is whether the service consists of the provision of healthcare to individuals or groups of individuals. And the third is whether the service falls within one or more of the specified CPV codes, which are in Schedule 1 to the PSR. We've also seen a panel decision which concentrated on this question, and there's a reference on the slide there for you in case you want to have a look at it. It is helpful because it gives you an example of how the panel approached this question. And in that case, what they were looking at is the question of whether the wheelchair element of the service was in the scope of the PSR. And what they did was they worked through the specification and they worked out whether they thought that it was a healthcare service and whether it was a relevant healthcare service. Now, your assessment is fact specific, and it might be that the facts don't apply, but it does give you a good example of how that can be approached. Once you've established whether some or all of your service is a relevant healthcare service in the scope of the PSR, then if there is some of it that is not in scope, that's where you then come on to apply the mixed procurement test. We've put it on the slide there for you as a reminder. There's also information on it on the NHS England statutory guidance. Ultimately, what we're saying is that it is not a one-size-fits-all answer. And each time you need to work through your specification, work out whether you think the PSR applies. And it's critical that when you do that, you document your decision and your rationale for that decision. I'll pass you back on to Andrew so that he can talk to you about system working.
Thank you, Helen. And I think just to pick up on Helen's point, when you look at this, there will be some contracts that it will be blindingly obvious that they are caught by the Procurement Act. There'll be some where it is blindingly obvious it is caught by the provider selection regime. However, there are a number where it could be either, depending on the specific circumstances. And I know when we ran this webinar back on the 3rd of December, that a lot of the questions we were asked were, I have service X, is it PSR or Procurement Act? And the fact is that you need to look at the facts and ascertain and work through the tests. And I think the starting point for me in terms of how I would do it is to look at it and go, does it fit within the PSR? Because if it does, then of course it's a PSR service. If you look at it the other way and go, is it Procurement Act? Well, you're missing out on the PSR there. So I think that's the way I would go about looking at it. But it is something that I know that people say, well, it's obvious. We know which rules apply, which hat we need to wear. But I can assure you there are a number of people up and down the country who are contacting us on a regular basis to ask those questions. So it is something that needs to be considered. And as Helen has said, it can cause a number of issues during challenges where actually you're in the wrong regime. So it doesn't matter how good your PCR or Procurement Act process was, if it should have been under the PSR, because you have different requirements that you need to comply with. It is worth noting that there are a lot of organisations who are trying to avoid the Procurement Act, as I alluded to earlier. They are trying to use frameworks to continually call off the PCR or modify contracts under the PCR to avoid the Procurement Act. Clearly, there will be an increase in Procurement Act activity as there is a decrease in public contracts regs activity. You can't obviously now set up a new framework under the public contracts regulations because it's post-February. Frameworks will exist, and as they start to come to an end, the amount of Procurement Act activity will come up. So the next thing that we wanted to look at was some specific issues for the NHS working together. Looking at NHS subcos, horizontal arrangements, and the delegation model. Now, when we were back in April this year, I thought we would be talking in our winter webinar more about NHS subcos than we will be, given that Sir Jim Mackey announced that there was a desire for organisations to set up subcos. Obviously, since then, the mood music has changed. And it's now going to be far harder to establish a new NHS subco, not least because you'll have to have the unions on side, which has been one of the issues with setting up subcos since they first started and were previously known as wholly owned subsidiaries. But the question is, what about existing subcos? Is it possible to change the scope of an existing subco? Can the scope of the existing activities undertaken by a subco be expanded? Indeed, I was in one of our other offices yesterday, and a colleague came to talk to me about a subco looking at the minute about changing how they might want to structure their arrangements and do things slightly differently. What is permitted in doing that? Well, in order to look at what is permitted for subcos, you need to be looking at vertical arrangements in the Procurement Act. So vertical arrangements are are exempted. They replace the previous Regulation 12(1) arrangements, which replaced the historic way of referring to this as a TECL arrangement. But if you are looking at changing your existing subco, then you need to make sure that you are complying with procurement law when doing so. Your contracting, a subco will be a contracting authority under the Public Contracts Regulations or the Procurement Act. If it's not, then you haven't set your subco up right, because the owning organisation needs to control the subco as if it was one of its own departments. But if you have a subco, it is not a relevant authority under the provider selection regime. So the provider selection regime doesn't have the horizontal and vertical arrangements that the Procurement Act does. So a relevant authority would have to enter into the contract. The subco could support that relevant authority, but the contract couldn't be in the subco's name. There then, and this is something also that came up significantly in the previous webinar, around horizontal arrangements. So horizontal arrangements is the replacement under the Procurement Act for what used to be the Hamburg exemption and then Regulation 12(7), effectively where public bodies are jointly exercising public functions. These are now deemed horizontal arrangements under the Procurement Act, and if you meet the test, it will be exempt. But this is not an exemption that applies in the provider selection regime. So if you are an organisation wanting to work with another organisation for a relevant healthcare service, you cannot use a shared service or horizontal arrangement because the PSR doesn't have those provisions in it. The test for what is a horizontal arrangement is set out on the slide. So it is contracts between contracting authorities, and only where both of the cooperating contracting authorities have public functions. So the arrangement needs to be intended to achieve a common goal in connection with the exercise of the relevant contracting authorities' public functions. The arrangement is solely in the public interest, and no more than 20% of the activities envisaged by the arrangement are intended to be carried out for reasons other than for the purposes of their public functions. If you have an NHS body X contracting with an NHS body Y, where Y provides services to X and X pays Y for those services, that is not likely to meet the test to be exempt as a horizontal arrangement. If they are relevant healthcare services, obviously the PSR would apply, and therefore it wouldn't apply. So there are ways to structure arrangements so that procurement law doesn't apply, but you do need to look at those on the facts and make sure that you can meet the tests. And that is something that we've been looking at with a number of clients over the course of this year, particularly how subcos might fit into any kind of horizontal arrangement. But there is another way that you could seek to avoid procurement if you're a trust or a foundation trust, and this is to use section 65Z5 of the NHS Act 2006. And if ever there was a citation that showed you how much the NHS Act gets changed, the fact that we are at 65Z subsection 5 really does highlight that. This is something we've been advising a number of organisations on, again, over the course of this year. because what Section 65Z5 does is permits trusts and foundation trusts to make arrangements for any of their functions to be exercised jointly or by another FT or trust. It's an alternative to a service arrangement. You still need to document it. You still need to set out how that arrangement is to work and how that is distinguishable from what is a contract. But if you do this, then it would be exempt from procurement. A feature of this, though, is that the 2006 Act sets out that any liabilities incurred in respect to the exercise of any delegated functions under such an arrangement are enforceable against the body that has been delegated the functions. So you need to document your arrangement, but if you do so, who you delegate to is liable for the exercise of those functions, but you, having delegated them, remain accountable for those functions. So you've got to make sure that you're setting this up properly. And also, as subcos have been considered this year, we've been looking at how subcos can fit into these delegation type arrangements. So if those are something that might be of interest and help you avoid the requirements of the Procurement Act, then please do get in touch. We also want to talk about the ability to make a direct award. Now, direct awards, we need to be very clear here, are not direct awards under any kind of framework agreement. These are direct awards which, using old terminology, would have been the negotiated procedure without prior publication of a notice. Effectively, I give a contract to a provider because I think they meet one of the grounds that are set out in the relevant legislation. So previously Regulation 32 of the PSR, now Schedule 5 of the Procurement Act. This is in relation as well to services that are not caught by the PSR. The list of what is covered and what allows you, and when you're allowed to make a direct award, is set out in Schedule 5, and it's highlighted there. The thing to say about direct awards is that you need to make sure that you can meet the tests that are set out in the schedule. So urgency, poor planning is not a justification for urgency. It's got to be something that is truly urgent. Of course, if you're thinking about single tender actions, single tender waivers, etc., then you should be considering whether or not the Schedule 5 grounds apply. But the real big difference with the Procurement Act is the amount of transparency that you need in terms of direct awards. I'm not saying everybody did this, but there are a number of organisations who historically would make a direct award, hope nobody noticed, have a sleepless 6 months of nights, wait until ineffectiveness was no longer applicable, and then be able to sleep soundly knowing that the direct award hadn't been met in terms of meeting Regulation 32. But what we have now under the Procurement Act, and indeed is why a number of people wanted the Procurement Act to come in on the 1st of April so that you could get your year-end direct awards in without having to publish these notices, is that there is now a requirement, if you are making a direct award, to publish a transparency notice. Previously, you had the option to avoid the first ground of ineffectiveness of publishing a voluntary ex-ante transparency notice, a VTN, people called them different things, but effectively a number of organisations didn't publish those because it was a red rag to a bull, because you were publishing to the market, I have made a direct award to X, my justification is here, and if the justification couldn't stack up, that was opening that up to criticism and challenge by the market. Now, there is a requirement under the Procurement Act to publish a transparency notice and to leave a mandatory 8 working day standstill period in the majority of cases. This leads to a number of questions as to how you deal with the notices for making a direct award. So a relatively busy slide, but that is because there is relatively lots of things to consider when you are looking at the notices to make a direct award. You may have, to be honest, in practice, I think it's unlikely, but you may have published a pipeline notice, a preliminary market engagement notice, a planned procurement notice. More likely, you need to make a direct award, and therefore you publish a transparency notice. You're publishing this on the central digital platform, and you ought to be doing that as soon as this decision to directly award the contract is made. It kickstarts limitation. You then, though, need to start a standstill period. To do that, you need to publish a contract award notice. Now, for reasons that I'm not clear, there is no definitive time period between a transparency notice and the contract award notice. You can theoretically publish them simultaneously. You might publish them on the same day, but ultimately you need to publish a transparency notice, then the contract award notice to start the standstill. Then you're having your standstill. And then, assuming you can award that contract, you are publishing a contract details notice within 30 days of award. And if the value of your contract is above £5 million, you're also publishing a copy of that contract. Now, this makes it far harder, if you are going to be compliant with the Procurement Act, to sweep things under the carpet. What this, I think, means in practice for you is those involved in procurement are well aware of the changes to the Procurement Act. They are well aware of the increase in notices. It's what most people are talking to us about, other than contract management, that we're coming on to. But do your key stakeholders within your organisations know about these requirements? It is often the case that the first time procurement know about a contract being awarded is when a request for PO comes in so that the supplier can be paid. Those people within your organisation who are having those conversations, potentially making those direct awards without being cognizant of what the requirements are exposing the trust to challenge. And therefore, one of the key things we think is to make sure that your stakeholders are kept up to date as to what the new requirements are and make sure that the proper process is followed. Now, I've spoken about notices being an issue. I think that the bigger issue for contracting authorities is contract management and the greater emphasis on contract management that the Procurement Act has introduced. When I first started procurement over 20 years ago, I'll say it quick. When I first started procurement in terms of the regulations was to get you from advertising an opportunity to who had won. And once that had happened, procurement basically went and started another process. Then we got the Suki de Fruta and all the different cases about variation and material variation. And then procurement needed to be involved during the lifetime of the procurement, looking at potential changes and whether or not they were fitted with one of the safe harbours or whether or not that was a new contract opportunity. The Procurement Act has meant that procurement needs to be involved in the entire life cycle of the contract. Notices have to be published throughout, not least if you have a contract that comes to its natural end, a notice still needs to be published to say the contract has come to its natural end. So that's where within your organisations you need to decide if that is a contract team issue, a procurement team issue, but ultimately it's a procurement issue and therefore you need to make sure that people are aware of it. But there's a lot of organisations that are particularly nervous about the contract management requirements, given that there is not exactly huge resource to do contract management historically. Teams are being squeezed, as I alluded to at the beginning, and but then there is a need to manage contracts. But before I actually get to what the Procurement Act requires about contract management, I think it is worth just looking at some very simple questions. These are not intended to be as patronising as they sound, but they are issues that we come up with on a regular basis when organisations ask us whether or not they are able to terminate contracts for breach. So the first question, and I'm not going to ask you to put your hand up or own up to this, could you, hand on heart, say that for all of the contracts that your organisation has entered into, you know where those contracts are? This is getting better with the likes of the Atomis portal, etc., that people do know. But often the first battle is finding a contract and what are the terms. It's knowing when the contract ends so that you don't then have to rely on or seek to rely on urgency when you can't because you haven't planned far enough in advance. What are the performance management provisions? It is a regular occurrence for us, for organisations to say, I've had enough of supplier X, I just want out, please get this contract terminated. And we ask, well, can we see what the performance management regime was? Have you notified them in line with that contract that you have concerns, give them a chance to rectify them? And that is where the answer often comes back. We don't know where the contract is, never mind what the performance mechanism provisions are. So you need to have your contract and manage providers. Who internally is responsible for managing those contracts, but in practice, how critical is the contract? If there is a resource issue, then you're going to need to prioritize your more critical contracts, your higher value contracts, than those of lower value. Practical issues. How will you manage the contract? What's important for that particular contract? Make sure when you're drafting your contract that you include your contract management requirements, include the provisions in the published contract, so that suppliers are aware of what is coming. Formalise the contract and sign it. The NHS in particular uses a lot of standard contracts. They have boxes to tick for certain provisions to apply. It's not, though, just a tick box exercise. A number of issues arise for us where we're asked to look at the exit of a supplier. So we say, well, can we see the contract and the exit schedule? It will say the exit schedule is in Schedule X, but the box has been ticked to say those are what the provisions that apply, but Schedule X is blank. So again, it sounds obvious things to say, but things that do arise on a day-to-day basis. You need to actively manage the contract. Have your contract meetings with your supplier. Tell them if they're not meeting something. If you tell them they're not meeting something, they are likely to try and change that. If they're unaware that you're not happy with the service or the kit that's been provided, then why would they do anything different? Pick your issues up early and follow the contractual requirements and plan for the contract end. Give yourself enough time to run a new compliant process. And prepare any new contract that you're working on. And this is particularly the case now with starting processes under the Procurement Act. If something has been bugging you under the contract that was awarded under the PSR, that they're not doing X or they should be doing Y, make that a contractual requirement in the next contract going forward. And of course, comply with the requirements of the Procurement Act. Now, these are set out. I think most people will be aware of these. You need to set at least 3 KPIs for contracts above 5 million. You need to publish that. You need to assess performance. You need to keep KPIs under review, and if you're permitted to, amend those KPIs. But you also need to make sure you're publishing breach and poor performance notices if required. There's a couple of situations that are set out on the slide. So the first situation, a supplier has breached a public contract and the breach results in termination or partial termination of the contract, the award of damages or a settlement agreement between the supplier and the contracting authority. Or secondly, a contracting authority considers that a supplier is not performing a public contract to the authority's satisfaction, has been given proper opportunity to improve and has failed to do so. There are notices that are required. So if a breach does not lead to full termination, you'll be publishing a contract performance notice. If a breach leads to full termination, you're publishing a contract termination notice. Both notices will have extensive information. It's on the slide. You're going to have to set out the result of the breach, what the breach was, amount of any damages or monies paid, and a link to any court or tribunal decision. What is this actually going to mean in practice? Well, first of all, you're going to have managed your contracts. You're going to have to have published your notices. But what are suppliers going to think about this? Well, if you're publishing breach and poor performance notices, that's going to have a reputational impact for suppliers. If we have consistent poor performance, then it's going to fall within a discretionary exclusion ground, and therefore other contracting authorities may subsequently disregard tenders from that supplier, exclude them, not make direct awards, not call off, etc. And there may be situations where a contracting authority has to report these breaches up to the PRU. The supplier ends up on the debarment list. The debarment list, I think as everyone is aware, is the list which, if you're on, you can't provide services to the public sector for the period within which you are on that debarment list. So this, as far as we can see, is likely to become a particularly contentious area. Parties often disagree about breaches and poor performance, but historically they may have been dealt with by some form of confidential settlement agreement. I think that's less likely to be possible under the Procurement Act, and therefore suppliers are more likely, we think, to pick issues with authorities who are saying they're not meeting the requirements or wanting to publish these notices, because it's going to be easier to challenge you as a contracting authority than it is to challenge your place on the debarment list. But remember, as you're doing all of your contract management, this still falls under covered procurement, so the objectives set out in section 12 apply. So there's lots of things to consider, but we'll now hand over to me. There you go. That's how planned we are. Hand over to me, because I've got the wrong slides in front of me, to look at subcontracting. There is a question that we've been asked around how subcontracting works under the Procurement Act and whether or not contracting authorities need to run processes when they are subcontracting. Under the Procurement Act, just like there was under the public contracts regulations, there are two schools of thought. One is that it is a opportunity that is above threshold, and therefore there's a requirement for a contracting authority to run a process to select subcontractors. There is another school of thought which means that puts any public body at a disadvantage as compared to a private sector provider who doesn't need to run any form of formal process to select their subcontractors. This is and has been untested. Historically, a number of contracting authorities took the view that the purpose of procurement was to open the requirement up to the market, and it was up to the market to decide how they came together to respond. Others were of the view that, well, it's a contract that's above threshold, therefore there's a requirement to run a procurement. So what you need to think about is how you deal with subcontracting, and that's going to be a risk assessment. I think we are likely to see the potential for greater challenges under the Procurement Act around subcontracting, given that there are requirements in the Procurement Act for contracting authorities to understand who their subcontractors are and get information from them. It may well be that there is a need and greater push towards running procurements to award contracts to subcontractors, but we'll have to see. The position under the provider selection regime is much more straightforward. Any subcontracting is caught by, if you're subcontracting a relevant healthcare service, the relevant authority needs to be complying with the PSR when subcontracting. As the slide says, that's not necessarily easier, because how do you run a PSR compliant process when you're wanting to subcontract to someone that you've bid jointly with? But that, I think, is for another time. So now it's time to hand over to Helen to talk about the PSR.
Thanks, Andrew. So as we say on the slide, the provider selection regime has been in force for nearly 2 years now. And just to be clear, it is still in force. It still applies despite the introduction of the Procurement Act. but it has been updated to incorporate changes from the Procurement Act. So, for example, it's got some changes and some extra sections coming from the Procurement Act on the exclusion side. So when you are looking at the PSR, make sure that you're using the latest versions of regulations and also the NHS England statutory guidance, which has also been updated. As organisations are continuing to apply the PSR, we are getting a variety of questions from them, and we've given you some examples on the slide of some common things that we see. So, for example, we get asked about which decision-making processes to follow or whether a particular modification is permitted. A common issue that comes up is the use of framework agreements for services within the scope of the PSR. So if you're calling off from an existing framework agreement that was established under the PCR for services which are within the scope of the PSR, then the PSR will apply. And what that means is that you'll need to comply with the requirements of the PSR as well as complying with the terms of the framework agreement. Now, we have seen an example of this coming up and creating an issue. So an organisation had called off from an existing framework which had been established under the PCR, and they had followed the ordering procedure in that framework. But when we came to look at it for them, we identified that the service was a relevant healthcare service in scope of the PSR, and the process that had been followed didn't comply with the PSR. So that organisation was left at the end of its process having to decide whether to abandon or not. The other thing that is coming up quite commonly, as more procurements are being carried out and people are becoming more familiar with the regime, both relevant authorities and providers, is lots of representations and lots of referrals to the panel. Now, we were going to prepare our own slides on the panel's processes and on dealing with representations. But a couple of weeks ago, Andrew Taylor, who is the chair of the Independent Patient Choice and Procurement Panel, spoke at the HCSA conference. And with Andrew Taylor's permission, we're going to show you the slides that he talked through, because that gives you the panel's view on what is important and what it wants you to know about. As Heather said at the start, you will be getting a copy of today's slides. So what we're not going to do is go through and talk through every slide in detail, but we will just run through them with you and pick out what we think are some of the interesting and important points from them. So in terms of this slide, it gives you an overview of the composition of the panel. And a key thing to note from this is that you've got 5 part-time panel members plus the chair. So ultimately, the panel doesn't have an infinite amount of resource to deal with referrals from providers. On the next couple of slides, there is an overview of referrals that have been made to the panel and those which have been accepted. So what this is telling us is that the panel will not necessarily accept every referral that it receives from providers. And when we were at the HCSA, Andrew Taylor said that the limit of cases that the panel can deal with at one time is probably around 5. So this slide provides us with an overview of the panel's case acceptance criteria. If you want to see the full version of them, that is available on the panel's page on the NHS England website. And these are the criteria that the panel applies to determine whether to accept a referral from a provider. So there's 2 sets of criteria. First, there are the eligibility criteria, and that determines whether a referral is eligible for review by the panel. But even if a request is eligible, there's also a second set of criteria that you can see on the right-hand side of the slide. And that is how the panel decides what it's going to accept when it's approaching full capacity. So this slide gives us an overview of the types of relevant authority that have been involved in cases considered by the panel so far. And when we say so far, we mean at the time of the HCSA conference. So mostly they are procurements by ICBs, although that could be the result of who's doing the most commissioning under the PSR, because we certainly see issues coming into trusts that don't get to the panel. This slide gives us an overview of possible outcomes if the panel accepts a referral. So once the panel has considered the matter that's been referred to it, there are 4 possible types of advice that it could give. It could find that the PSR regulations have been followed and there's no problem. It might find that the PSR regulations have not been followed, but the breach hasn't had a material impact on the outcome. Or it might find that the regulations have not been followed and advise the Commissioner to either return to an earlier step or to abandon the current provider selection process. So this gives us an overview of outcomes so far. And what you can see on that slide is the majority of cases, the panel has determined that the PSR has not been complied with. And in over half of cases, the panel has advised the relevant authority to go back to an earlier stage of the process. And then this slide and the next slide give us an overview of the types of issues being considered, and that gives us some insight into what's most common. This slide, the second one, is really useful. So if you've got something that you're thinking about, or you've got a question and you want to see what the panel has said about that before, this slide is effectively a matrix that tells you which types of issues have been considered in each case report to help you go quickly to the right case reports. And if you're particularly interested in that, Andrew Taylor has posted an issues log on LinkedIn, so you could have a look at it on there as well. So on this slide, the panel's highlighted what it sees as key points to draw to your attention and some key cases on the choice of procurement process. So for example, it's got the orthotics and wheelchair service case that we mentioned before. Anecdotally, we've seen a provider complaining that a relevant authority chose to follow the competitive process when the conditions to follow direct award process C were met. Now, that is a situation where the relevant authority has discretion to choose the process. And what you can see on the slide is the panel saying it's regularly rejected complaints sort of along those lines, and it's given some examples of cases where it's done so. The panel's saying here that it has seen a lot of cases regarding the use of the competitive process, and it's picked out scoring as a commonly raised complaint, and that certainly aligns with our experience from what we're seeing. Helpfully, Andrew Taylor has given us some pointers in terms of how the panel will approach a scoring complaint. So, like the court, the panel won't substitute its own judgment about what the correct score is. Instead, it's focusing on the procedure. So, did you do what you said you were going to do? Were bidders treated equally? Have you moved the goalposts during the process? On this slide, you've got a reminder of the conditions to be met for you to be able to follow direct award process C. And also you'll see that the panel's emphasising here that when you're deciding whether you can follow direct award process C, you need to make sure that you've carried out a critical analysis of your existing provider's current and likely future performance, and that you have documented that assessment as part of your record keeping obligations. So on this slide, the panel's picked out a couple of issues that it considers to be key from what it's seen so far from the most suitable provider process. So for example, that includes the conduct of the process. So you're not inviting offers, you're not running a competitive tendering process. You need to follow the process in Regulation 10. And if you have a look at that case that's on the slide, the Staffordshire and Stoke-on-Trent case, in that one, the ICB encountered issues because it didn't go into the procurement with an open mind. So instead, what it was doing was trying to use the most suitable provider process to confirm its pre-existing preference for a particular provider. So again, here the panel is highlighting aspects of the representations review process that it considers important from what it has seen with referrals that it's dealt with so far. And the highlight is that the panel expects you to provide information to providers that has been requested and that you are required to at an early stage, and to then allow providers to consider that information and, if necessary, to explain or clarify their representations. What you're not expected to do is to provide the information that a provider has requested along with the outcome of your internal review having already done it. So what you can see on this slide is just that the panel is highlighting that where information is being given to bidders, it expects that to be accurate. And it also generally expects the disclosure during the representations process to be greater than that elsewhere in the process. And that's because when you're running processes under the PSR, providers have more limited access to the courts where disclosure would happen. So importantly, though, not everything gets to the panel. The panel thinks that it's not seeing many cases, and that's because what the panel sees is probably the tip of the iceberg. On this slide, we've tried to pick out some things that you can do as part of your internal review. So first, get your governance processes right. The NHS England statutory guidance states that relevant authorities should ensure that appropriate internal governance mechanisms are in place to deal with representations made against provider selection decisions. So if you haven't already got one, set up a policy for dealing with representations, and then that helps you out because you've already done a lot of the thinking, the planning before you get that representation in. And if you do receive a representation, you can simply follow the process that you've already set up. Remember that following your internal review, you've got 3 options in terms of the further decision. You can proceed as planned at the start of the standstill period, or you can rewind, so return to an earlier stage in the process and repeat that in subsequent steps, or you can abandon and start again. And if you're rewinding or abandoning, then that representation won't meet the panel's acceptance criteria and can't be referred on. And also think about timings. So the panel's standard operating procedure says that it will endeavour to provide advice within 25 working days, and when it accepts a referral, it will provide a timeline. What we're seeing anecdotally is that it takes a lot longer than that. So when you're planning your processes, make sure that you start them early enough and that you build in time to deal with representations properly, and also to allow for panel review as a contingency. So I'll just pass you back on to Andrew.
Thank you, Helen. And I think it's interesting, the number of panel decisions is going up because obviously more people are now using the PSR. The rumour mill is suggesting under the Procurement Act, for example, there are 10 cases that have 10 claims that have been issued at court, but of course we don't have any of the outcomes of those. We will start to see those, and this is how things are going to develop. So I think it's useful to see what Andrew Taylor's saying, because that is what he thinks are the important issues under the PSR. And I think that's why we've done it that way, as Helen said, with his permission. So just to finish off, and before we get to questions, I know there's a number in the chat. A number of you, if you've heard me talk before, may have seen this slide. But I think it's important that we talk about the Procurement Act. We talk about the provider selection regime. We talk about the public contracts regulations. We talk about what that means in practice. But ultimately, the things that often go wrong with procurements are a multitude of things. It's not normally one thing that brings down the process. It's suppliers wanting to unpick a process, and that's why we have procurement is like a game of Jenga. What suppliers are trying to do is unpick the bricks at the bottom and bring the tower down, the tower being your process. And what procurement professionals need to do is to try and cheat at Jenga and superglue the bottom of the tower together to make it as stable as possible. So just to finish off, just some things to really think about. And this is aimed obviously at contracting authorities, but if you're a supplier, you can flip it round as to what might be the things that need to be looked at. Avoid the easy wins for challengers. So we've talked about it at length. Make sure that you are using the correct regime. Deal with conflicts of interest. This is both under the PSR and the Procurement Act, and I see one of the questions we'll be coming on to in a minute is talking about conflicts of interest. Run defensible processes. That sounds an obvious and really quite trite thing to say, but if you prepare from day one to be challenged, you're more likely to be able to defend it. And that kind of comes through the next number of bullet points are on there. So do what you said you were going to do. If you say you're going to do X, do X. If you don't, then you're deviating from your process. You're not following the relevant principles, objectives, etc. Carefully consider your criteria and marking methodology. There is not a one-size-fits-all approach, and you need to make sure that your criteria work and that evaluators will be able to use them, and that the marking methodology fits in with those questions that are being asked. So think about those carefully, because as anyone that's been involved in procurement will know, the evaluation moderation stage is the key stage. And we are advising organizations to train their evaluators and their moderator or moderators as to what the obligations are. And we have a number of issues at the minute. I know there's at least 6 that we are dealing with as we speak, where we have been asked to review debrief. We've not been asked to review the process. We've not been asked to review the evaluation. We've been asked to review the debrief. And that is throwing up a number of issues on processes. And I'm going to use a hypothetical situation to avoid embarrassing anyone that may know people that are involved in these. But let's say that the marking methodology says, in order to achieve a score of 3, you must meet all the requirements. The question says, for question 1, please, in your response, show that you cover A, B, and C. We are seeing debrief currently that is proposed to go out that says they met requirement A, requirement B, but not requirement C, but they still are being given a score of 3. Now, that, if you are a challenger, is something that will just open the floodgates of you wanting to challenge, make representations, whatever you want to do, because it is clear from the debrief that the marking methodology hasn't been complied with. Often you have situations where evaluators don't give sufficient reasons for their scores. Moderators don't make sure that there are sufficient reasons. That is a key issue that needs to be considered. And audit trail, as Helen said, the panel expects information under the PSR to be disclosed, retained, etc. If you don't have an audit trail under the Procurement Act, then you're going to have real difficulty trying to defend anything as well as you would under the Public Contracts Regulations. Think about your debrief for the reasons that I've just mentioned about. It is when you're telling the suppliers who's won and who's lost, and it's when they get upset. You're going to have to deal with issues in the standstill, making sure that the standstill is calculated correctly, noting that you calculate the PCR, PSR, and Procurement Act standstill all in different ways. And as Helen's already mentioned, complying with requirements of frameworks. As I've alluded to earlier, there's a number of organisations that are trying to put things through existing frameworks to avoid having to run processes under the Procurement Act. That means there has been some questionable shoehorning of requirements into frameworks. And if you are not meeting the requirement of that framework, you will likely be picked up by the framework providers who know those frameworks inside out. So it's just important to try and cut out these easy wins and then make your processes more defensible. So can I just check where a contract falls within the scope of the light touch regime under PA and the contract value is below the threshold, section 8488 would apply. Is this correct? I will hand you to our resident below threshold expert, which is Helen, to answer the question.
Hi, Lee. Yeah, it will. That is the answer. So you will have to comply with the below threshold requirements in Part 6 of the Act.
Okay, Fiona, your question about whether or not you could use horizontal arrangements for universities to councils, whether or not this is an NHS focus or not, the position is, if you are a contracting authority wanting to use a horizontal arrangement with another contracting authority, depending on what sector those contracting authorities are in, there is a need to make sure that you are able to meet the test. So do you have public functions you both have to perform? If the answer to that is yes, then that will work. If the answer to that is no, then you'd be running a risk in using that horizontal arrangement. Okay, so the next question talks about the PSR guidance and conflicts of interest, and the fact that the NHS England guidance is primarily aimed at ICBs and NHS bodies. There is a need to make sure that if there, in terms of conflict of interest, I think it would be worth noting that no conflicts were identified and making that available so that people can see that. Lee's next question about economic operator. I don't think there is a definition of economic operator in the Procurement Act. Anything to add, Helen?
Yeah, so now instead of economic operator, we're thinking about contracting authority, aren't we? And there's a definition in section 2, which is similar, sort of part of the test is about whether person is wholly or mainly funded by public funds or subject to public authority oversight.
Kimberly's question about the panel. Now, this is a can of worms question, Kimberly. The panel has set out how it should operate, and it should be looking at the representation that is made. But, and this is a decision that the panel gave earlier this week, the panel has made it, for example, this is an example, the panel has made given advice to a relevant authority on a representation that was received on a rerun process. The panel has made comments in its advice about the original process that was run. So we've acted for clients at the panel, and it's a very open and kind of wide-ranging discussion that you have with the panel when they meet with you. But ultimately, the panel should be following the requirements of the PSR. They should be addressing what is in front of them. But we just have to see how the panel gets to deal with issues as they go through. Can you provide the main issues you are coming across in terms of process for evaluator training? Well, in terms of evaluator training, the training that we do to evaluators looks at what the requirements and obligations on an evaluator are. And a lot of it is relatively obvious to those involved in procurement. It's less obvious to those who may be using an NHS example, a preeminent surgeon or clinician who is brilliant at what they do, but doesn't understand the finer points of the audit trail that they're required to give when it comes to a procurement. So it's looking at what's required, some key tips in evaluating, level of audit trail, etc., that is required. So in terms of staff, Julie, and how that works, you need to look at what the arrangement is. It may not be a PSR service because it's not a service. Depending on how the arrangement is structured, it might not be a PSR service, but you'd have to see whether or not it was covered by the Procurement Act. Oh, I've been asked $1 million question about thresholds for the PSR. I know that there is a growing, I think there always was quite a large desire, but a growing desire amongst organisations for a threshold to be introduced for the PSR. At the minute, I'm not aware of any intention to change that. Obviously, the PSR is going to have to go through some amendments when NHS England is amalgamated into the Department of Health and Social Care, because currently the department is not a relevant authority for the purposes of the PSR. So that's going to have to change. Introducing a threshold, though, would not be a consequential amendment that would come from that. So it would require separate legislation. So if you think there should be a threshold, keep lobbying NHS England, but I'm not sure whether or not that is something that will materialise in the near future. And Kimberly's asked the other issue that we were asked in the previous webinar. At the minute, I'm not aware of any plans to change the notices for the PSR to have a bespoke PSR regime. But again, these are all things that may change when the department takes over the responsibilities of NHS England. Neil.
Yeah, thanks, Andrew. Really useful. In terms of a PSR competitive procurement, a two-stage process, giving suppliers feedback at stage 1 that they're not proceeding to stage 2, what's your view on whether they are able to make a representation at that point when no contract's actually been awarded, and what do you think the national panel's view of that would be?
National panel's view, Neil, I have no idea. What you would find if you ran a multi-stage process under the competitive process is that the only time that you can make a representation is when the standstill period starts. So you would be in the bizarre situation that a supplier would have been excluded, but they wouldn't be able to make a representation formally to you that you would have to consider until the standstill period was started when they received that notice. They then could bring the process down at that point if their representation had merit. Suppliers might make representations at that point anyway, but it wouldn't be a formal representation, it'd be a letter. If you then considered that representation during the standstill period and while that had been extended, and you said that your process was fine, then that would be available to go to the panel at that point. We'll have to wait and see if that ever materialises to the panel now.
Yeah, thank you.
We don't have links on our website to the most up-to-date legislation. That's because we, as a firm, pay for updated legislation that we can access, but our license terms mean that we can't give that out to everybody. So it's unhelpful. For example, when you Google, if you type in PSR regulations, you get the draft version. You don't even get the most up to the published version when it came into force. So it's something I think could be more helpful. And I don't know, I haven't checked recently, but it was also the case that when you Googled the public contracts regulations a few weeks ago, you couldn't actually access them because it said they've been repealed, even though they, of course, apply to any process that you're still continuing to use. So it's not the most helpful situation. I appreciate that. Thank you all for joining. Wish you all a happy festive period in 2 weeks' time. I am now panicking. I hadn't realised it was that close. And thank you very much. If there's anything we can help with, please give us a shout.